Do you spend a lot of time worrying about legal ethics issues? Do you find the ethics rules and their comments hard to understand? Relief is at hand for those who attend the State Bar's annual Solo and Small Firm Conference. Hello, I'm Jeff M. Brown, the legal writer with the State Bar of Wisconsin. I'm here today with Stuart Teicher, a lawyer who specializes in ethics issues. Stuart will be presenting at the Solo and Small Firm Conference, which will be held October 27th to 29th at Kalahari Resort in Wisconsin Dells. A virtual replay with the presenters available in real time to answer questions will be held November 14th to 16th. Welcome, Stuart.
Thanks for having me. Welcome. Well, I'm saying welcome to you.
Yeah.
Well, welcome to me.
Yeah, great. Good to meet you. On your website, you talk about those lessons hidden in the ethics rules that enhance a lawyer's practice. Can you give us an example or two?
You want me to jump right into the boring stuff? Is that how it works?
Sure, sure.
Tell us about ethics is really, really boring. Can you tell us about some ethics? Well, sure. I have a little bit of a different view of the rules altogether because I really do think that they can be a guide for how we can become a better lawyer. And it's not just something that we on the ethics board, and I sit on the disciplinary board here in New Jersey. It's not just something that we on the disciplinary board can, use to hit lawyers over the head with. And a perfect example of that is what I call the Grand Troika of the ethics rules, rules 1.1, 1.3, and 1.4. And you know that if I'm throwing around a word like troika, that I read one too many Tom Clancy books in the 80s, because I think I might be the only person who mourned the loss of the Soviet Union because of Tom Clancy's books have stunk since the Iron Curtain fell. But 1.1, 1.3, and 1.4, competence, communication, competence, diligence, and communication. If you were to pull out the different elements of those rules, they really give us a roadmap about how to be great lawyers, about being prepared, having the legal knowledge, skill, communicating with our client. So I really think that if you look deeply at the rules, at some of the key ones, you can get a roadmap, a checklist of how to be great at what you do.
So I wanted to drill down on one of those with competence, being knowledgeable about the practice area or the case you're going to take on. I did most of my work as a government attorney, but for a while I was out on my own doing some things, and entertainment law in particular. And I was mostly handling music law copyrights for bands and musical artists. But I was approached by a filmmaker. He and his brother wanted to raise some money to make a film, mainly from relatives. And I did some research and found out that when you do that, that's actually an offering. That's a security. And to help him with the paperwork, the SEC paperwork that needed to be filed, I had to bone up on securities law. And I remember talking to some people who were like, "Ooh, I wouldn't go near that." Or I remember when Oregon, this was in Oregon where I practiced. I remember when Oregon added the requirement to buy professional liability insurance, a lot of people stopped even going near security stuff because the insurers wouldn't take it on, or because the risk was too great for the insurance. I forget which. I ultimately decided, because I really wanted to help those two filmmakers and branch out into doing film, not just music, to go ahead and bone up and consult with some security lawyers to do that. I think it was just a Form D. It was one relatively, in the world of security, one relatively simple form. But I mean, I had to think long and hard before I did that, and then put some time in. So, is that an example of the kind of thing where people need to be extra careful, or how much diligence do you need to put into taking on something that's a little bit out of your wheelhouse?
Interesting question, because I'm not doing this program at the event we're talking about now, but I did a program that dealt all with the issues of collaboration and competence as you just discussed it. And the thing about the world that I work in the disciplinary world, is that we work on two tracks. The disciplinary system enforces the ethics code, but malpractice, which gets to more to that insurance issue you were talking about, is obviously, civil law and things like that. The interesting thing about securities law too is that now you know why the malpractice companies have you fill out a separate rider if you're going to do securities work, that kind of stuff. But ultimately, the place they intersect clearly is what you're talking about, is the issue of competence. The rule 1.1 has a series of comments in the commentary that deal with competence and acquiring competence by associating with other people. It's one of those places that is really, really soft. I like to call it soft because you don't get the exact advice that you're looking for when you read those sections. You really got to take a look at the particular facts in your situation, who you have available, when you're going to collaborate, what you already know, and you got to take those several comments and apply it to what's happening in your situation. For example, some of those comments deal with emergency situations and how you might get a little bit more leeway of being able to work on a matter where your competence isn't as, you're not as comfortable with your competence as you'd hope because it's an emergency situation. But if it's not an emergency situation, you still can acquire that competence by associating with other lawyers, but you might have to delve a little bit deeper in order to acquire that competence before you actually do the work. So it is one of those sections that causes problems for lawyers. So it's kind of a double-edged sword. Yes, 1.1 is one of the Grand Troika that we can use to become great. But when we start to look deeper into the comments, we realize that they still can be used against us, so to speak.
Well, you mentioned the comments, and I mentioned that in my lead-in. And to make a two-pronged religious reference, those things seem to me to call for almost a biblical exegesis, or they remind me of the midrash, right? So, I mean, how great a resource can those be? Is there something additional where people interpret the comments, or can you get guidance? What should someone do when they're looking to delve into one of those comments to get some more?
It is so funny that you throw out the word midrash there because I grew up going to, my mother had a variety of ways that she liked to torture me as a typical stereotypically Jewish mother, one of which was clothes, which I don't want to talk about because the twitch will start to come back. But the other way is that she sent me to Hebrew school until I graduated from public high school. And she didn't send me to the local synagogue. I had to get on a bus and schlep to Manhattan to 123rd Street and Amsterdam Avenue to the Jewish Theological Seminary where they ordain rabbis. And now, believe me, I am nowhere near a rabbi, but we used to talk about reading the rules we talked about reading the scripture in depth. And I talk now in my programs about reading the rules like their scripture. And the fact that the commentary is a little bit different than the rule is exactly the approach that I take with my students as well. When it comes to the rules, every word is precious. You got to remember how the rules were created. The American Bar Association created this massive code. They sent it out for public comment. It came back down to the states and they did the whole thing all over again. So if anything was changed, you really have to make note of that because the individual states made those changes purposefully, even what appear to be insignificant changes. They're not insignificant. And then when it comes to the commentary really is like that explanatory section of the code. And the commentary is both helpful and frustrating because it's helpful in that it gives you some additional guidance. The reason it's frustrating is because it's probably addressing those gray areas. And ultimately, what's going to end up happening is that you're most likely, as a practicing lawyer, going to be forced to make some kind of judgment call. And say, all right, here's the issue I'm dealing with. Here's what the rule says. Here's how the commentary interprets it. Nothing is exactly on point. I got to make a call. And that makes it very difficult for lawyers. It makes it frustrating.
Well, and it kind of, it has to be that way, right? Because you're never really going to know the answer until it gets litigated, which would be bad because you'd be the subject of the litigation, right? So
yeah,
understood about frustrating.
That's one of the reasons why I say that when lawyers are trying to interpret how they behave under the rules, you really want to kind of go back and think about the underlying reason for the rules and let that guide your analysis. The rules are there to protect the public and our clients from both unscrupulous and incompetent attorneys. And if you start with that, you use that as your starting point and you rest all of your decisions and analyses based on that foundation, I think it makes it a little easier because then you realize it's not about you. It's right. About client. And I think that helps.
The logo for your podcast is a man in a suit tearing open his suit coat, Superman style, to reveal a t-shirt that reads, "Legal ethics is cool." Have you always enjoyed legal ethics, even back in law school? And if so, why?
Just so you know, my goal is I think if I say it enough, people will actually agree with me. Or at least maybe a couple of people. I call myself an ethics geek. And I don't know why I like it so much. I think, here, listen, I tell people that I sit on the ethics board in New Jersey because I have an altruistic desire to give back to the practice, right? But the truth is, I just like to judge other people. And that's what I get to do on the ethics board, is to judge other people's behavior. And I think that's what fascinated me from the beginning, was the idea that really ethics as a area of law is really about judging other people's behavior. At least it is in the attorney disciplinary world, because, you know, whether or not you want to consider what we do ethics is another story, but the disciplinary code, so to speak. I actually got started in law school. I took a course on corporate compliance, and that's really what got me going. I remember to this day who my professor was, a in-house counsel for what was then SmithKline Beecham, and I think they had a big office in Philadelphia, because I went to Rutgers Camden, right over the bridge from Philadelphia, and he was in-house counsel, and we did a lot of issues on corporate compliance, and I found that stuff fascinating. And after that, I took some more professional responsibility courses, and I don't know, it just kind of sunk in with me, and it's been something I've liked ever since.
Can you give us a preview of your talk at the Solo and Small Firm Conference?
Sure. So I'm giving two programs. One is what my Facebook posts teach about lawyer mental health. And the other one is called What the Bad Lawyers of Hollywood Teach About Attorney Ethics. And as you can tell from my titles, I'm a little bit of a different type of speaker. I actually gave myself a nickname. I call myself the CLE performer. And even though I know it's ridiculous for one to give oneself a nickname, my theory is we've got to get important content. I just like us to stay awake in the process. And that's what I strive to do. So I noticed when I was traveling around the country for all of the speaking that I do, that a lot of people on the road annoyed me, and or I saw funny stuff that I would post on Facebook. And I said, wow, you know what? This really can teach us some lessons about the importance of maintaining our mental health, you know, being frustrated in airports and stuff like that. So that hour is going to be about mental health as seen through my eyes on the road. The other hour that I'm doing is what the bad lawyers of Hollywood teach about attorney ethics. And this, I'm telling you, this is volume 1. There are so many more, like Michael Avenatti and that stuff hadn't even come up when I wrote this for the first time. So whether it's Johnny Depp's lawyers, Bill Cosby's lawyers, or even some lawyers of politicians, they really do teach us some important lessons that lawyers who have no celebrities as clients can really use. And it's really just two programs that use what I think are just kind of interesting, fun ideas. And I make the connection to attorney ethics so that we can get our important hours in a way that's tolerable.
And hopefully edifying. I'm sure it will be. Stuart Teicher, thank you for the time. Look forward to seeing you in October for the conference at Wisconsin Dells.
My pleasure. Thanks so much for having me.